Right. I think there's another thing that we didn't mention yet, and that is, what if you have a younger spouse? So I had this happen a few years ago, and part of the problem again is that when somebody dies, what happens quite often is the beneficiaries try to self-administer the assets. And of course, technically, again, as we said, it may not be under the estate or the trust anyway, but they don't go and consult. They don't go and get advice before they take these actions. So anyway, I had this situation. It was an older gentleman that married a younger woman, second marriage, like you said. It was okay with him for her to have the thing. Well, she immediately rolled it over into her own name. The problem was she was under age 59 and a half. And so she comes to me and she says, well, I want to take this money. And well, you know, you can take some money, but it's very limited. It has to be, again, a life expectancy type of a computation. Otherwise, you have a penalty tax that applies. And she was very upset.
And had she gotten advice, a planner would have told her that she could withdraw money from the plan as a beneficiary without penalty, as she wanted. And then once she reached age 59 and a half, because she was the spouse when he died, she could then do her rollover at that later date.
Right.
And she wouldn't have been penalized as before. Another example, Mike, of when someone should not do a rollover is when the surviving spouse is older than the deceased spouse, and the deceased spouse is under age 70 and a half, because the surviving spouse will not be required to do any minimum distributions until the deceased spouse would have reached age 70 and a half. And so they can hold that money in that account longer. If they do the rollover right away, then they'll have to start taking minimum distributions when they reach age 70 and a half.
Right.
And unfortunately, if you call the mutual fund companies, or oftentimes you talk to your broker, they're not familiar with these rules. Everyone just knows spouses do rollovers. And they don't really talk to a tax professional about the consequences of that. Right.
So what it comes down to is you will have different consequences in different scenarios. Depends. It's very much a case-by-case situation, because again, if the spouse has lots of assets, then they don't need to take the distributions. Again, maybe they had a life insurance policy or something like that that's providing funding for them. But otherwise, maybe they need it, and so then they'll want to do it. So anyway, you really have to look at the case facts in each case when you're trying to.
Another example too is sometimes the surviving spouse doesn't need this money. And remember what I said when we're looking at our general principles. The second principle was younger rather than older. Oftentimes the surviving spouse may want to disclaim this money and let it go to the kids right away, who are younger than the spouse, and therefore will get the benefit of this money over a longer period of time. But if the spouse does a rollover, they're not going to be able to make that disclaimer later.
Too late, yeah.
And so you have some time. You don't want to rush into doing these, filling out the paperwork and stuff. You want to make sure you get qualified advice so you can consider all the scenarios before you rush into the one scenario that may lock you in forever.
Right. Okay, well, another area related to a surviving spouse or planning for a spouse is a Q-tip trust, qualified terminal interest property. So why don't you elaborate a little bit there about some considerations for having a Q-tip trust related to a retirement account?
Well, anytime we put a retirement account in a trust, that trust has to be specially drafted with language in it that requires the income or the distribution to pass out to the surviving spouse. It's what we call conduit trust language. Now, we use the Q-tip trust so we can qualify for like a marital deduction, on our estate taxes, make sure that we have the property not being taxed right away. But because it's in the trust, the spouse only gets the distributions out from the trust and doesn't get everything, doesn't get to roll it over or anything like that. So it can be a way, for example, like in a second marriage or where it's my money, my kids, type of situation, to make sure that the spouse is taken care of, that you covered your estate tax issues, but you're not allowing the spouse, complete freedom to do whatever they want with that property.
Mm-hmm. So related to this, the purpose for the Q-tip trust was to design a trust that does protect the assets, particularly for ultimate beneficiaries, but also qualify for the unlimited marital deduction. Now this year, things are in chaos, so we're going to talk about, really sort of a more conventional estate tax law, but that's a big part of the reason for using this type of language. And there's an election that's required on the estate tax return in order to treat it as a Q-tip trust, so people have to remember that. It doesn't just automatically happen.
Well, and sometimes it's not even, we don't have clients necessarily who even get to the Q-tip trust that need to take advantage of this. For example, a client may own a house and a very large 401k.
Yes.
And that's all the assets they have.
Yes.
Well, if you leave the IRA or the 401k directly to the surviving spouse, you may not have enough assets to completely fill up your estate tax exemption trust.
Right.
And so in that type of situation, we may want the credit shelter or the bypass trust to be the beneficiary. And what we do in our office oftentimes is leave it to the surviving spouse with a disclaimer provision back into that trust so we can analyze at that time, which is why we don't want to rush into making decisions.
Yeah.
But this allows the surviving spouse to kind of look at all of the options before making a decision and protecting that asset from estate taxes if that's the only asset we have to fulfill it.
Yeah. So we're talking about choices that you make before a death and choices that you make after, and so and you're trying to provide that flexibility for people to have more choices afterwards. There's another wrinkle to this Q-tip thing, as I understand it, and that is that according to the probate code, that the small amount of the distribution is actually allocated to income, and so may not actually be distributable to the spouse. So you need to have some special language to enable that to get out to the spouse.
Absolutely, or you violate your rules for the trust.
Yeah.
And yeah, it's a complex area of law, and well, as you know, since the IRS put out these rules in 2001, financial planners and CPAs have been a lot quicker to understand them than attorneys. And we still have problems in this county with attorneys not understanding these rules and regulations. But even then, the IRS has had to put out 7 to 10 private letter rulings a month trying to explain what these mean and how you can use them. Mm-hmm. So it's an area of law that's constantly changing. Mm-hmm. And you want to make sure you're getting the best advice at the time you're doing your planning, because the rules may have changed from 1 year to the next.
Okay. So another area that we talked about, of course, a big consideration is children. And so what considerations do we need to think about related to children or other beneficiaries of a person that's making an estate plan that has one of these retirement accounts?
Right. Well, obviously younger rather than older, and most of the time clients treat all their children equally. And they're not really factoring in what type of job they have or something like that. But we do want to think about, is the child likely to stretch this out, use it over their lifetime, or is this going to be all out at once so I can buy a Cadillac Escalade, a big screen TV, and then there's no money left, right? Mm-hmm. Studies show that beneficiaries who receive $500,000 or less will spend it all in 18 months. Mm-hmm. And some will spend more than what they receive and get in greater debt than they ever were before.
It's a little